Next case on the court's calendar, State of Florida versus James J. Norris. Ms. Schuman.
Good morning. May it please the court. My name is Belle Schuman. I represent the state of Florida in this case. The issue before the court this morning is whether the rules of criminal procedure permit the first appearance judge to modify a bail bond when a person is arrested pursuant to a warrant and the issuing magistrate has set a firm amount of bond.
Let's go through this from the beginning, if we could. I think it'd be helpful. We're dealing here with a warrant.
An arrest warrant.
An arrest warrant in
Yes, sir.
Norris case. Now, would you agree that under the rules that the situation is different for a capias and a warrant?
Well, in both of those instances, it is an order by the judge that a person be arrested. I see no practical difference between those two. Well,
what is the state's reason that there would be a specific section in J under 3.131 for a capias, and there's no mention of a warrant?
Well, sometimes rules are used interchangeably. Words are capias, arrest warrant, bail, bond, those sorts of things. The state would suggest that there's no real distinction between those terms.
Well, but there is a distinction between a capias and a warrant, isn't there? I mean, there's a specific statute and rule that deals with warrants in 1229 or 130.
Well, certainly there's a distinction between what causes it to be issued. A capias is issued sua sponte by the court from the bench. An arrest warrant is at the behest of law enforcement, who comes before the judge and gets the judge to review the probable cause affidavits and the other information that establish probable cause. At that time, the judge also sets a bond and indicates whether or not that bond can be modified.
But in both situations, the judge doesn't have the defendant before him or her, to actually determine what the bond is.
That's correct. It's a non-adversarial hearing.
And in one, the state attorney, I would assume, because the capias is issued after the indictment or information has been filed?
That's correct.
And the state attorney is the one that's asking the court to issue
That's true.
the capias?
Yes. It's generally for failure to appear. In my understanding, that's the general, when someone has missed a court appearance, such as arraignment, a capias generally issues from the bench. And yes, but in either case, the defense would not be present.
So I guess the question still is why one is treated differently from the other. Why should a judge be able to say on a capias that you cannot alter the bail and they can on an arrest warrant?
Well, because it's further governed by Rule 3131D. In both situations, an amount of bond is set if it's a bailable offense. On an arrest warrant, there's a further indication of whether or not that bond can be modified by the first appearance judge. In the cases before the court this morning, there was an indication, first of all, that there was probable cause. Second, that the amount of bond was fixed at a set amount.
And how is that fixed? How is that amount determined?
It's determined like all other discretionary matters before the issuing magistrate. He reviews the affidavit. He reviews the history of the person that is related in the arresting affidavits. Perhaps there's been prior threats of violence. Perhaps there's been other failure to appear.
But what about all the factors that a judge is required to consider, such as family ties, financial resources, length of residence, employment history? How is that? That can't be determined in a non-adversarial, non-recorded situation without denying a constitutional right?
That's correct. It's a non-adversarial hearing. That's correct.
But why do you call it a non-adversarial hearing? Isn't it an ex parte hearing?
Well, in some instances, yes. It's an ex parte hearing, much like the decision to issue a capias if the defendant is not there. Ex parte, it's non-adversarial. Both sides aren't present to present the full facts. We're not saying that that's a one-time
Well, one
fixed
side
rule.
is there, is it not?
That's correct.
Okay, you said both sides. Okay, so this is an ex parte proceeding is what it is.
Yes.
Okay, only
In
one
both
side is
instances.
heard, right?
in both instances, it's the
Correct.
ex parte proceeding.
That's right. We're not saying that this is bail. This is
Isn't bail supposed to be heard, though, with the considerations such as Justice Perrianti outlined? That is, that we time after time have outlined what the factors are, and how can that happen in an ex parte hearing?
Well, the state certainly agrees that in an adversarial bond hearing, those are the determinations that are considered. But much like when an arrest warrant is issued, there's been a determination of probable cause for the arrest. You don't re-argue whether there is probable cause at the first appearance hearing. If you're arrested without a warrant and you go to first appearance, then the initial first appearance...
Isn't that the reason for that, though, that it's the defendant has a right immediately to have a neutral magistrate in an adversarial proceeding determine these factors? And that's classically the way that a bail determination is supposed to be made, is it not?
Yes,
Can
however...
you say that a fair bail determination is made absent that?
Initially, yes. Because the person, just like if someone is arrested pursuant to a warrant, there has been a probable cause determination for the arrest. There's been a bond set. Just like the person retains the right at a later date to have an adversarial determination of probable cause, he also retains the right
Why
on
should there be any presetting of the amount of bail without an adversarial hearing? What is the necessity for that? Since somebody is arrested, and clearly they cannot be released until a judge does set the terms of bail, where is the need to have, in an ex parte proceeding, an arbitrary setting of a bail amount?
Because the issuing magistrate has before him the probable cause affidavits. Perhaps they've known if the defendant has threatened the victim in the past, or they set the amount of bond based on the factors of the crime.
Well, I
That's not
realize
fixed.
they do that, but where is the necessity for that? That is, doesn't that same issuing magistrate know that before that person can be released on bail, in conditions, whatever, that it'll have to go before a judge, a neutral judge that will have the ability to determine this laundry list of proper factors? So tell me where the necessity is for an ex parte proceeding to determine that when there's going to be available immediately an adversarial proceeding, which we all agree, and I assume the state would agree, is the best way to do it.
Well, I would respectfully disagree with that because...
Why isn't that the best way to do it?
Well, because when an issuing magistrate in, say, Tallahassee, reviews the facts of the crime, reviews the prior history of the parties involved, the defendant may be arrested in Tallahassee, he may be arrested in Key West, and a Key West judge has no knowledge. The state attorney from Monroe County knows nothing of the case, although there is a state's representative there. If the issuing magistrate in Tallahassee, after a full review of the affidavits, the facts of the case, says, I'm going to set this bond until, and I don't want it changed until that defendant comes back before me for a full-blown adversarial hearing, then he's in a better position than any judge within or without the state.
Well, and
Setting it.
could actually work to the advantage of the defendant.
Correct.
I would take it, because that way the defendant can immediately be released.
That's correct.
But let me ask you this: what is the state's position on what the provision in 3.131D or 2 means, where it says the judge at the defendant's first appearance consider all available relevant factors to determine what form of release is necessary to assure the defendant's appearance? It would seem to me that if we strip the first appearance judge of discretion, that's sort of an empty provision of this rule.
Well, in the majority of the time, the first appearance judge sets bond. However, in those just like the first appearance judge doesn't make a second probable cause determination, we're stripping him of that determination. We're also, in those instances when there's been an arrest warrant, There's been an amount of bond set. We're saying we're going to maintain the status quo until we can get all interested parties, give them all notice, and get them before a magistrate. So it's just in those instances where it hasn't already been done. There has already been a judicial determination of probable cause. There has already been a judicial setting of bond and an appropriate amount.
Are you using setting and endorsing in the same way?
Yes. My opponent suggests that endorse means much like Michael Jordan endorses tennis shoes, that it's a mere suggestion, a recommendation. The state contends that the more appropriate interpretation of that word would be to affix one's signature to, and that it is in fact a judicial order.
In either way, it is not the setting of the bond. It's an endorsement. And as Justice Wells said, as your opponent has suggested, it's for the purpose of that if someone's arrested and they want to be able to get out of jail immediately, they have an amount that they can post and they can get out of jail. So it's an additional protection for the defendant. But where do you see in the statute or the rule that it is therefore then a preclusion of the first appearance judge to actually have a determination to actually set the amount of the bond? And I guess that's where we're going back to whether if we say endorsement does not mean setting, then we're going back and looking at the rules, and the rules seem pretty clear as to what's supposed to happen at first appearance.
Well, we would rely on D part of that rule that says subsequent application for setting or modification of bail. Subsequent application. Now that rule says that no judge of equal or inferior jurisdiction may set or modify a bond unless he is, D part says, the first appearance judge and was authorized by the judge setting the bond. If this rule does not contemplate that, well, it does contemplate that in some instances first appearance is going to be the subsequent hearing, or else D wouldn't be there.
Now I guess that D was there because if at the point when the first appearance judge sets it and the defendant's not happy, this isn't going to allow the defendant to go find a judge that's going to set a lesser bond.
Right.
That's what that protection is. I mean, so what you're really saying is that what we have to do is interpret our own rules, and you would agree that we have to interpret those rules consistent with a defendant's constitutional rights.
Well,
do you agree with both those propositions? Number one, this is a rule construction.
it is a rule construction.
Okay, and second, that however we construe this, whether it's ambiguous or it's not, that we've got to construe it consistent with the defendant's constitutional rights.
Well, there is no Fourth Amendment constitutional right involved here. These rules are derived from
I'm talking
Gerstein
about
versus
the right
Pugh.
under the Florida Constitution, the right to bail.
Well, under the Florida Constitution or the federal Constitution, the First Amendment rights are governed by the Fourth Amendment. They're solely derived, the procedures and standards for arrest and pretrial detention are derived solely from the Fourth Amendment. And under Gerstein versus Pugh, there isn't even a constitutional right for a first appearance hearing at all if there's someone that's arrested under an arrest warrant. So there's really no constitutional right involved here because it's governed solely by the Fourth Amendment. And the cases cited in the brief having to do with federal constitutional rights, there's really no constitutional claim here because it's derived solely from the Fourth Amendment.
But one of the problems I have with this is you had said earlier that the judge who issues the arrest warrant he sets or endorses, whichever term you use, an amount of bail and says, this can't be changed until you come back to me.
Right.
Well, suppose this is not the judge who the case is assigned to, and there really isn't any reason to ever have gone back to the judge who signed the arrest warrant. What happens in those situations?
Well, there's A or B parts of the rule that says if it's the circuit court, the chief judge of the circuit, or the judge to whom the case is ultimately assigned.
So you've got to wait until...
Can be modified. Yeah, there has to be 3 hours of a defendant can obtain an adversary bond hearing on as little as 3 hours notice to the state. But the state needs to have some notice, whether they're arrested in Tallahassee or Pensacola or Key West. They have to have some notice to be able to be, the victims have a right to be there, the law enforcement officer has a right to be there. There's nothing in this case that indicates that this judge had before him the arrest affidavits or any of the information of the crime. The first appearance judge has the defendant and the ties to the community and those factors. The
But
issuing
also,
magistrate has the other half.
Isn't the state there at the first appearance hearing also?
Yes, but it's wherever he happens to be arrested. He may or may not know a thing about the case. So the state is there, that's true, but a state attorney from Escambia County doesn't know anything about a case from Monroe County.
But the state attorney knows that this first appearance hearing is coming up, and so
Well, when they show up
Theoretically,
that
anyway,
morning,
you
they're
could-
handed a list of cases of the preceding 24 hours arrest. That's true. They know that there is going to be first appearance. It's the defendant who knows where he's going to be at any given time, not the state. That's why we need
So
to
are
have...
you then advocating that when you come to this first appearance hearing, the defendant then, and the judge on the arrest warrant has said, this amount cannot be changed? It is at that point that the defendant then requests a hearing?
He could at that point. But at some point, he has to go back before either the issuing magistrate or back to the circuit where the arrest warrant was issued, because that's the place where they have knowledge of the facts of the case. And they can put both halves together. The halves about the defendant's information and hear from the victims and the other interested parties who have, at that point, notice of what's going to happen. This is nothing new. We don't permit forum shopping. We don't permit forum shopping in bail determinations.
In this case, though, aren't we in a situation that's unique, apparently, in this county, where by order, there's a particular judge that is the first appearance judge. So within that circuit, they can adjust if they want to change assignments or do something that will, but the defendant's not forum shopping. The defendant's going before the first appearance judge. How is the defendant forum shopping? The defendant didn't know who the arresting judge was. It was done without his or her presence, and the circuit has designated who the first appearance judge is.
Well, by going to Hernando County, he knows that he's the one and only one judge that is going to. Now, maybe he's in Hernando, maybe he's in Key West, maybe he's in Pensacola. We don't know where he's going to be when he is arrested. We don't permit modification of bond by anyone other than the judge who set the bond in the first instance or the chief judge of the circuit. That's not a novel concept. And the reason for that...
The judge didn't have to say that this cannot be changed. I mean,
No.
The judge who issues the arrest warrant could just leave it blank. And
Correct.
So then anybody...
Absolutely, and that's the situation in McCoy, and that's exactly right. But because that issuing magistrate has particular knowledge of the facts of the case, of the perhaps prior threats or perhaps knowledge or that's related in the affidavit that the person is especially dangerous for some reason, he sets an amount of bond and then further orders.
But
yes.
that's not necessarily true. I mean,
No, it's
all a judge really has to have to issue the arrest warrant is enough information to determine that there's probable cause.
That's correct.
And so you really don't have to have any kind of additional information about
You don't
the
have
defendant.
to, but you could. And that could be a reason why, as Judge Goshorn observed in his experience, that the issuing magistrate may set the amount of bond and then further indicate that it cannot be modified until by the first appearance judge under the Rule 131D.
What is the role, what is the state's position as to the role that the victim's right provision in the state constitution plays in this setting of bail?
Well, certainly at all critical stages of the proceedings, the victim has a right to be heard. Parties have a right to be heard. The state attorney with the information relating to the crime, law enforcement, other witnesses may wish to come before and be heard on the issue of whether the bond should be lowered. The victim may come before and say, look, I've received death threats. I'm in fear for my life. Please don't lower the bond. That is the kind of information that the issuing magistrate would have, that the first appearance judge, wherever in the state, probably would not have before him. So the state is not saying...
Is it in the field a routine practice for the state to give notice to the victim of the matter having to do with the reduction of bail?
When there is an adversary hearing set and all parties have notice of when and where it's going to be modified, I would certainly believe that yes, that all interested parties would be present. The point is they have notice. Whether they are there or not, they have notice, they have time to prepare. Both sides have time to prepare. Not just one side when it's the issuing magistrate, not just the other side at first appearance. But it's not until you have an adversarial hearing that both sides are there and can give a full and fair, constitutionally required consideration of the issues.
In this case, what were the factors that the issuing magistrate relied on in setting the, endorsing the bond at $20,000? Were there prior threats? What was there?
There's a very sparse record here because it came up as a writ of prohibition.
Isn't there a sparse record because you're never going to know what was in the judge's mind when he set the amount because there's no requirement that it's be specified? And isn't that the problem, is that if a defendant thereafter tries to go and modify an amount that's been set, they don't know what factors the judge even used to get the amount to set the
In
amount.
all instances, we presume that judges exercise their discretion based on legally identifiable factors. As far as this particular case, there is a sparse record. But we're looking at the larger picture here. And the larger picture is when an arrest warrant is issued in Pensacola, and that judge has affidavit and information, sets a bond, and then takes the further step and indicates, I don't want the first appearance judge wherever in the state. I want to have the defendant to come back before me or some other judge of this circuit. I don't want the bond modified until that time. We're not saying that this is a one-time fixed ruling. We're saying that we need, in some cases, there has to be a way to maintain status quo once the person is arrested until there can be a full hearing.
Would you advocate a different rule if the arrest takes place in the same circuit where the arrest warrant was issued?
The rule is adequately stated as it is. The rule says a subsequent application or modification of bail can't take place by a judge of equal or inferior jurisdiction unless it's the first appearance judge and they were authorized to do so under the arrest warrant. If they are not authorized to do so under the arrest warrant, they cannot do so under the clear meaning of the rule until the adversarial hearing at a subsequent time.
If you wish to say.
I'd like to read.
You may.
Yes.
Thank you, Chairman. Ms. Osborne.
Good morning. I'm Elizabeth Osmond, and I'm here on behalf of the respondent, James J. Norris. I would like to take issue with some of the answers that the state provided the court with their questions. We've thoroughly briefed these issues, and I'm sure the court's aware of the respondent's position.
Well, let me start off with you
Yes.
with the same question I started with
Okay.
the state. Do I read your papers correct that you're not challenging the capious part of this administrative order?
That is correct.
So we have a situation in which if there is a capious and it's done ex parte too, quote, ex parte, and that the defendant's not present at the time that
That's
the court
correct, yes.
issues the capious.
A capious issues upon the state attorney's signature on the indictment or the information,
And the judge endorses the bail.
and the judge endorses that particular bond.
And that, from that standpoint, the only difference is that the state's attorney is involved in the capious as opposed to law enforcement involved in the warrant.
Well, I think it's also a second review. In order for the state attorney to issue the information, the state attorney has certain duties under both their ethical obligations and the rules.
But the way this works in a capious is that then the court that issues the capious can say whether or not there should be a further determination made in respect to bail.
That is correct.
And if the judge decides there should not be, then at first appearance, there isn't any further consideration.
That would be correct.
Now, so we're not, you're not saying that there should be any change in that procedure. You're saying that the warrant is such a distinctive proposition that first appearance, that there should be an examination of the amount of bail which has been set at first appearance.
That's correct, and that there is a separate rule governing the capious and governing the ability to modify the bond that has been, as in a word, endorsed by the judge.
Despite the separate rule, explain to me why you believe that the first appearance judge should, in fact, be able to change the bond based on a capias and not on a warrant. I mean, in either situation, as I see it, the defendant is not there. In one situation, you have the state attorney there. One, you have law enforcement there. What is the real difference in those two situations?
Personally, I don't see that there's a major difference between the two. It's simply that the legislature has elected, or the Supreme Court has elected, to implement rules and statutes that govern them separately. This case came up on a warrant.
Purely based on the rule.
Yes, this case came up on a warrant case. That is how we got here, and under the construction of the rules and under any, when you strictly construe the penal statutes, it clearly says that a capias requires the modification and you can't change it without, and the warrant, that is not involved. When you have a statute that does not involve that language, it therefore has to inure to the defendant, and the defendant is entitled to his first appearance bail hearing.
So then, following up, then we're not really discussing or constitutional rights that are being implicated. We are simply construing rules of this court?
I think that both are at issue. I think
could there be a constitutional right if the person who's arrested on a capias has the bond endorsed on in an ex parte hearing and doesn't have that first appearance right, and one that gets arrested pursuant to an arrest warrant does, and somebody who's just arrested for sure does? What's the governing constitutional principles that allow that to occur?
I think the constitutional principle would probably be the same if the capias issue was addressed, whether or not that particular rule is constitutional or not. It nevertheless is not the same as the rule available for the warrants.
So you're just saying we don't need to reach the constitutional
Correct.
issue because we've got something that our rules are that you say are fairly clear.
Correct.
You're not
I think
saying
it
that we should
separates
say that
the
it's
two.
okay with the capias, it's just not before us.
It's just not before you. And it came before you on the particular issue of the warrant. I think to deny the defendant his right to an effective and meaningful first appearance bond hearing is unconstitutional. I think your defendant is entitled to show all of the things that the courts and the legislature have provided to him, that being the ties to the community, the employment history, mental health history, and all of those things. There is no question the state has its rights also to establish the victim's testimony, the law enforcement, and anything else they wish to present. But the procedure for presentation is first appearance unless you fall under one of the specifically excluded areas, which include capital or life felonies, which include anything the state filed a pretrial detention motion on, which clearly is available to the state.
Well, then it would be your argument that the evaluation of the amount of bail would be a crucial stage of the proceeding.
I believe it is, yes.
And don't you have to notify the victim?
I believe that that's the state's responsibility to notify the victim. The state attorney is the first person aware of his pickup.
But what we're dealing with, if it's going to be done at first appearance, then you're going to have to notify the victim within 24 hours, and that's sort of a hollow constitutional right that the victim has if the person's arrested in Key West, and in fact the crime occurred in Pensacola.
I would disagree with that reasoning, because presumably whoever has issued, whatever state attorney or whoever has dealt with this initial case in that county has had contact with the victim. The state attorney of that county can certainly be notified, just as the defendant's counsel is obligated to notify parents. Can you post bond? What amount of bond can you post?
But the problem that I see is this problem of the mobility of the defendant being somewhere else other than where the alleged reason for the commitment is. and trying to work that with what the Constitution plainly says in Article 1, Section 16B, that the victim has a right to notice or be present at all crucial stages of criminal proceeding.
That would be the responsibility of the state attorney or law enforcement, and if the victim has relocated and they can't notice them, they're not required to follow them, merely make the effort to notify them. They can certainly be heard via telephone. They can be heard by the voice of the state attorney. There are ways to have parties heard, just as if he's arrested in Key West, I can notify Key West that I have parents willing to post $10,000. Or they can contact me. You know, do you have family in the area? What can he do? Those things are available. It is true that they are seldom done, but it is not because they're not available avenues. It is because they choose not to. And when they choose not to, they may not get the victim in, but it's available to them.
Is the judge that issues the arrest warrant obligated under our rules to endorse an amount of bond amount?
I believe it says that he shall endorse amount, but it does not say that it shall not be modified.
What is your understanding of the purpose of that subdivision?
So that anyone who is arrested and the rights upon arrest do go to the defendant. Upon arrest, he's able to bond out.
So in other words, because it doesn't allow the issuing magistrate to say, well, I'm going to release this person, the defendant, on his or her own recognizance, because that's something that can only be determined at a hearing where the defendant produces evidence as to why that should happen.
Unless you have a capital or a life felony, not having a bond set by someone, either law enforcement or a court, upon the issuance of a warrant, you would have to have a judge approached every time an arrest occurred, any time during the evening, because they are entitled to bond unless they're there on a capital or a life felony. We would have our judges getting up all night long every night answering, we picked up someone for DUI at 3 o'clock.
So your contention is that that subdivision is actually for the protection of the defendant?
I think it's for the protection of the defendant. I think it's for the convenience of the courts. I think it's for the swift administration of justice. I think we have to have some provision, and there is law asserting that there has to be some provision to allow something to occur from a 6 p.m. arrest until a 10 a.m.
But and if law enforcement is concerned about the danger that the defendant might pose, then the amount presumably is set high enough so that it's...
He's still there at first appearance.
Tell me how this works in real life in places other than Hernando County. Do you practice other places other than Hernando County?
I have practiced in Brevard County, which is a much larger...
Okay, in Brevard County, do we have this conflict between the judges as to whether they're going to allow the first appearance judge to set the...
In Brevard County, if there was such a conflict, I was not aware of it. I am aware of Tallahassee, that there was such a conflict, an unwritten rule, and that would be the Foudis case, which came behind ours, which was an unwritten rule where the judges informally agreed, to my understanding, informally agreed not to change each other's bond amounts that were issued on the particular warrants. In Brevard County, I am not aware of that particular issue, and I am not aware of whether the bonds were changed on warrants or not changed.
Well, in most instances where the judge is just not checking whether the first appearance judge could...
That was the case in McCoy out of Dade County,
No,
where
but
no
I'm
box
talking
was
about
checked.
your experience in
But
Brevard.
my experience in Brevard, I don't recall. I don't know if they checked it. Apparently, it was checked in Tallahassee, and it was not checked in McCoy, in Dade County. Other than that, I don't know.
I sort of assumed from this case that it was only because there was this administrative order that was entered by the chief judge of that circuit that we had any question about whether the first appearance judge could or could not change this bond. Is that not true?
I think it initially began that way since I filed it as a writ. I filed it as a writ to release the defendant and have a bond hearing. It went up on the issuance of the administrative order. The 5th DCA broadened that to encompass the bond issue at first appearance. I think
So the issue has been sort of, it sounds like, percolating in
Yes.
other circuits
I think it's
despite
been-
no administrative
I
order.
think it's been percolating without administrative orders, and in FAUTUS, I am aware that the issue in that arose out of an informal agreement. So I think it's been around. As to the state's contention, as to the state's contention that this record is sparse, the state was an original party to the original writ and chose not to respond. The state had ample opportunity to respond and was served with the original writ. Responding to the original writ was only Judge Swaggart and Judge Heislip, who responded with counsel Chip Mander. The decision was reached at the 5th with the responses from Judge Swaggart, Judge Heislip, and myself on behalf of the respondent Norris. Mr. Norris, the other thing I want to be very, very clear about is the state's contention that you're entitled to a bond hearing within 3-hour notice is absolutely incorrect. The rule reads that you must give opposing party a minimum of 3 hours. Mr. Norris, whom the first appearance judge determined an appropriate bond was $1,500, sat in jail 2 weeks on a $20,000 bond before he could get a bond hearing. There is no maximum amount of time that they can sit before they get their, quote, subsequent application.
When did
Merely
he
a
actually
minimum.
apply to have that hearing?
When did I would assume within a day or two of the first appearance. I knew about it at the time of first appearance, and I may have actually contacted the judge he would be assigned before, secretary for time that day or the next day.
Would that be, again, now trying to decide whether the rules need to be modified or whether they're perfectly fine, if we were to construe the rule as the state requests, would you suggest that the rule would need to be changed to make sure that in this situation that there be a bond hearing within 24 hours?
Without question. Even on VOP, the case law has said that the defendant in a VOP has to go back before the judge that issued the VOP warrant because that's presumably he is responsible for the supervision. Even in a VOP warrant, that has been construed, they're required to bring the defendant before the judge who issued the warrant forthwith, and that has been construed as 24 hours. People are sitting in jail because they don't get.
But you haven't raised that as an alternative. In other words, if we construe the rule to be this, then there ought to be a right to go back before the original judge within 24 hours.
I think that that's correct. If that is the construction.
Have you asserted that as an alternative?
No, I haven't, because it is my position that any ambiguity inures to the defendant.
I understand that, but if for whatever reason we agree with the state, that would be an
In the initial writ, I asked for that particular remedy. The remedy that I received in the initial writ was my primary remedy, which was that the order was quashed, and the first appearance judge would have authority to modify the bond.
But you alternatively pled that there ought to be a right to a hearing within 24 hours?
In the initial writ. But I did not respond with that on my response to the Supreme Court because it came up on the broader issue. But at this particular point in time, given the rules and given the construction of the rules and given the fact that all penal statutes and rules have to be strictly construed, I think there is no question that the defendant is entitled upon arrest to a meaningful bail hearing at a first appearance. If that is difficult for the state, then the state attorneys need to make a more diligent effort to get their victim input, their law enforcement input, and whatever it is they need or wish to introduce. There is no question that the initial warrant, when signed by the judge, is done in an ex parte manner. Any assertion that he has any facts as to prior threats, anything like that, is not only outside of the record and not present in this case, it's also highly unlikely. Most often, at least in our county, this is going paperwork.
There's some allegation, and I guess it's not in the record, but that these are actually preset amounts that are just determined according to a schedule.
The preset amounts have come up and been added to the record by virtue of the 5th District Court of Appeals accepting judicial notice of a prior case. That there is a preset bond issue schedule, and often these are preset amounts. There is no determination as to whether the victim can or the defendant can or can't make it, ties to the community prior record. It would be extremely unlikely that a judge issuing a warrant would have any information whatsoever about prior threats or anything else. This is paperwork shoveled from the state
Well, what
attorney's.
about, though, if you would respond one more time before you sit down, to those situations where there are special circumstances,
Okay.
and the trial court that issues the warrant does have special information that the particular defendant is a threat to flee or is a threat to somebody's safety? How would you suggest, if we construe the rule the way that you're asking us to, that that judge who issues the warrant and then wants a special consideration because of that to any other magistrate that this may come before so that a mistake is not made, how would you suggest that that be accomplished?
I would suggest that the state file a motion for pretrial detention, an avenue available to them, and that they are responsible for. If someone is in danger, that is the remedy, to hold him in custody. And that can, if that's granted, whether the court is here or elsewhere, if that's granted, that defendant will sit in custody until he comes to trial. And that is the remedy to protect society from those types of issues. Is there anything you wanted to say?
How is that going to occur, though, as a practical matter, if we are talking about jurisdictions or venues that are different from the issuing warrants venue? That is, in other words, the extreme example being if the warrant's issued in Key West and the defendant is picked up in Pensacola. How is that going to occur as a practical matter, since in Pensacola they're going to have that first appearance immediately, the next morning?
By the same teletype or transmission that the warrant gets there. These people are getting picked up by teletype. All that it needs to say is that there is a hold for pretrial detention as well. Just as if he was picked up on 2 holds, one from the state of California as a fugitive.
Yeah, but don't you have a time limitation for that, for Leon County to go to the Keys to pick up that person?
I don't understand the question.
Isn't there, if a defendant is arrested in Key West on a Leon County warrant, and there's a fixed amount set in the bond, and they notify Leon County that they have the person in custody, isn't there a time limitation?
No, there's not. That's established by the first appearance or the county. For example, in our county, Pasco will pick up tomorrow. If you're arrested today, Pasco will pick up tomorrow.
But there's no limitation.
No, there isn't. In fact,
So a person can...
I have some knowledge of Key West and Dade County. Dade County does not notify Monroe County to come get them, and someone sat in Dade County, and this same issue was filed in Dade County, which is how I know about it, sat in Dade County for 2 weeks, and Monroe just simply didn't come and get them.
Okay. Thank you very much. Ms. Schuman?
Just a couple of very quick points. First of all, the state would like to draw this court's attention to the fact that 7 months elapsed between issuance of the warrant in this case and when Mr. Norris was actually arrested, to require the state and the victim and law enforcement to be prepared within that 7-month period each and every day for a full-blown administrative hearing is beyond the interpretation of the rules. It's also my recollection of the record, I'll defer to counsel on this, but the adversarial hearing was within 1 week and the bond was reduced. I would also point out to this court that modification can go either up or down. That if this court rules that you can have a full-blown adversarial hearing at first appearance, the state could also move to have it increased as well as decreased.
Well, there's nothing, what's wrong with that?
Well, certainly it cuts both ways.
Doesn't that actually protect the state as well and the victim, which is that maybe, again, because the issuing judge does not have all the information, so does the best in just setting an amount. And then we have exactly this situation where a reasonable bond can be set once all the interested parties are before the court.
Well, except that the interested parties aren't always the interested parties. The state attorney from Escambia County is not the same interest as the state attorney from Monroe County.
Hopefully in this day of communications and emails and faxes, all that should be far easier than it might have been 50 years ago.
That's true, but there's nothing in this record to indicate that the first appearance judge had those considerations. It's the state's position that the administrative order here is neither adds nor detracts to the state's argument. If the administrative order is in compliance with the rules of procedure, then it's valid. If it's not, then it isn't. So it's really all about, it's not about the Constitution, it's not about the administrative order. This case is about the rules of procedure.
But really, isn't this case about whether you're going to allow the judge that first has the defendant before that judge and the state there the discretion to make a determination as to whether that person should be released? I mean, that's what this case is about, isn't it?
Well, it's only in those instances where the issuing magistrate has taken that additional step and said, because under the rules, it says that if you are the first appearance judge and you are authorized.
All of these kind of situations, the parade of the horribles, where the judge in Pensacola is going to do something bizarre, it would be bizarre, because most of the time, if the judge doesn't have some reason given that the amount should be reduced from what's originally set, the judge is going to leave it there, isn't he?
One would hope that they would give due deference to the order.
Really?
Well, one would hope that they would give due deference and judicial courtesy would ordinarily cause that result. Yes, sir. As far as the state not responding, this came up as a writ and the state was not ordered to respond. That's why the state didn't appear in the 5th. As far as if this court chooses to amend the rules to put some sort of time limitation on it, the state would request the court to take into consideration the fact that you're still talking about a very large geographic state, and something like 2 or 3 working days would certainly enable all parties to have adequate notice and marshal their forces. I see my time has expired. I'll rely on the brief. Thank you very much.
Is there any, I have one last question, is there any time limitation on someone going to another county to pick up a person who's been arrested on a warrant?
I'm not familiar. I don't know.
Thank you very much.
Thank you.
Thank you, Counsel.